تحيتهم يوم يلقونه سلام وأعد لهم أجرا كريما.
The second pillar of inheritance is al-muwarrithu. Al-muwarrithu is the person who is leaving the estate behind, that is the deceased. And the part of the conditions that are applicable to the deceased is that his death must be confirmed, either by two just witnesses who confirm that he had died, or maybe by any other clear signs, as maybe testified to by a competent and reliable medical personnel. So that confirms the death of the individual. So by this, then the property of such a person may be inherited. Or there's also the possibility that the status of the death of the person may not be known, such as somebody who is missing, somebody who went to war, for instance, 5 years, 10 years, nobody has heard anything about him. So we don't know whether he's alive or dead. So the competent judge will declare the missing person, declare him to have the status of death. So he will be considered to be dead. So in that regard, his property will be shared among his heirs. So this is with regard to al-muwarrithu. Then the third pillar is al-warithu. Al-warithu is the heir, that is the person who is going to inherit. The person who is going to inherit must be somebody who is a legal heir and must also succeed the person who is inheriting. So, which means that the survival of a heir must be affirmed. If the survival of the heir of the deceased cannot be confirmed, then no inheritance can take place. For instance, in a situation where a father and a son, faliyadhu, are involved in an auto accident and both of them died, but the father died on the spot and the son died maybe a few days later. The son who died a few days later, when they are distributing the inheritance of the father, they must give to that son, even though he was dead. So the portion that should belong to him as when he is alive should be given to his own heirs, because just as the father has his own legal heirs, the son will also have his own legal heirs. So those who are the heirs of the son are the one that will inherit the portion that comes to their person. Allahu A'lam. So these are the three pillars of inheritance. So basically, it is important for us to understand that all of these pillars must be accomplished, must be present before inheritance can take place. Allahu A'lam. Now, it's equally important for anyone to claim to have a right to inheritance. We must know the roots of inheritance. We must ascertain the relationship that the person has with the deceased. Anybody can just come up and say, oh, I also have a share in the estate that the person has left behind. So we will ask the person, how? What is your relationship with? So what are the relationship that makes inheritance, that confers right of inheritance to an individual? The first of the relationship is kinship, such as sons and daughters, fathers and grandfathers, mothers, brothers and sisters, and the likes. So kinship. So if an individual has kinship with the deceased, then he has a right to inherit the individual. However, That is if other intervening factors are also in place. So, but the root of inheritance, the right of inheritance, is conferred by kinship. The second root of inheritance is marriage. And when we mention marriage, it means that we're talking of a valid aqdul nikah, that is a valid marriage contract under the Sharia. A living partner does not have a relationship that can confer the right of inheritance to him or her. Even if they have lived together for 20 years, but there is no nikah, there is no valid marriage contract as recognized by the Sharia between them, then they are not, they do not have the right of inheritance. So those that can, claim the right of inheritance through marriage can either be husband or wife. Can be husband or wife. And it does not matter. Ordinary marriage contracts, even if the woman has not moved into the house of the man, the fact that they have gotten married, the contract has been concluded, confers the right of inheritance to the lady if the man died first, and vice versa as well. And also in the case of divorce, for instance, especially the revocable divorces, the first and second divorce, when the woman is still under the iddah, she's still having her waiting period. If a man divorces his wife, the wife is required to observe a waiting period of 3 menstrual cycles. And while she is observing that waiting period, the man dies. If the man dies, his property is to be inherited, and the wife has a share in the property. But the man has divorced the woman. He has divorced the woman, but the woman is only observing her waiting period prior to become completely confirmed as no longer married to the man. Under the Sharia, a woman in a waiting period of a revocable divorce has a right to inheritance. Her right of inheritance is confirmed. So this is the rule of the Sharia. So the second root of inheritance is marriage. And when we mean marriage, a valid aqdul nikah, a valid marriage contract, even if there has not been any sexual intercourse between them, after marriage. If the man that, okay, they got married today, and while they were going home, something happens, it's an accident, and the man died. So there is no intercourse between them. There has never been any intercourse between them. Will the woman inherit? Yes, she will inherit, and she will also do iddah for the man. So this is the second root of inheritance. And the third root of inheritance is al-wala, that is patronage. This is in the case of when a man is the one who freed a slave. The inheritance of the one who freed a slave becomes a heir to the one he freed. So this is and there is a fourth one, which though it was it's a little bit controversial, though some of the scholars have mentioned that this is a root of inheritance. That is in a situation where a person dies and left no heirs, nobody to inherit him. Then the Islamic treasury, the Muslim treasury, inherits in that regard. So these are the rules, the rights of inheritance. If anybody is going to claim a right of inheritance, it has to be through this route. Is either he has a verified kinship with the deceased, or he has a marriage, valid marriage contract with the deceased. the idea of somebody that has been divorced very many years ago, and now just because, okay, the man now died, so he coming back to the house of the man, said that, oh, I am his wife. No, a divorce, if a divorce had happened and it's and the iddah has been completed and the woman has moved out, she is no longer a valid heir in this regard. So this is the rule of the Sharia concerning that.